Welcome to VidZet. I'm Dr. Ted Noel, and please accept my apologies for the long-winded and detailed discussions by Bill Hodes in our immediate past podcast. One of the problems when you have a professor who is very well versed in law is that he tells you all of the details. So what I'm going to try to do today is to just give a real short version of what went on, so that you can understand. Trump's executive order on immigration specifically lists 6 countries that are terrorist havens, have been documented and listed by the Secretary of State as terrorist sponsors, and that lack any governmental structure where there is either the ability or the cooperation to allow the United States to evaluate whether a particular person is acceptable for entry into the U.S. This is a simple, straightforward national security order. It was promoted under 8 U.S. Code 1182F, by which the President can restrict entry of anyone into the United States simply by declaration. Now, countering this is a suit by United States persons. So let me make it clear. This is not a suit by people who are not yet U.S. residents or granted entry. One of the people is a U.S. citizen who has an overseas wife who is going to be delayed entry under the order. And as a result, the claim is that he is injured because she's not allowed to come in. So it's not trying to give constitutional rights to foreigners. It's dealing with supposed injury to the United States individuals. Now, there is an argument being made that 8 U.S. Code 1152A says that you cannot restrict entry based on nationality. Now, as a key item here, this conflict actually has never been adjudicated at the Supreme Court, and it was never challenged when President Obama excluded all entry from Syria at one point. So this is an open question as to whether there is a conflict to be ruled on, and this is one of the things that happens. Congress writes laws, and the laws, because they're so big and they're so complicated, you have one section on the left hand that looks like it's contrary to the one on the right hand, and one of the things the courts have to do is to balance and decide how they work together, or if one of them has to be thrown out. So that's a real question. Now, one of the problems in this case is simply that these sorts of issues have been adjudicated in the past. And the key precedent is a case called Mandel. And Mandel dealt with a Belgian communist speaker who wished to come to the United States. And he was sponsored by some universities and whatever for his speeches. And clearly his speech would fall under the First Amendment free speech rules. And the Supreme Court clearly admitted that. But his free speech rights do not guarantee that he has a right to enter. The right to enter has to be granted before his free speech rights can be exercised. And as the court ruled, the power to exclude aliens is inherent in sovereignty. That is, you don't have a nation unless you can determine who can be here and who can't be here. And because Congress had ruled that communists were not allowed to come in and speak, then Mandel could be excluded. Now, there are a couple of things that go on in this case that make it incredibly important. In Mandel, the Supreme Court said that there was a facially legitimate and bona fide reason for excluding him. And anytime there is a facially legitimate, that is, you read the document and on its face it makes sense, and it's the reasons stated are bona fide, then the court has to honor the restriction. The court does not get to look behind what's bona fide. And they make a big point of saying you can't go back there to look behind for other reasons. But what does the Fourth Circuit Court do? It looks for other reasons behind Trump's facially legitimate and bona fide order. And what they do is separate facially legitimate, which they accept, and bona fide, say it's not bona fide, because it is a religious exclusion. Well, there are lots of arguments why that's nonsense, including the fact that Congress has specifically allowed religious preferences and exclusions in the past, and that 80+% of the world's Muslims are not affected by the order. In any case, in Mandel, the Supreme Court said, no, you can't look behind. But what the Fourth Circuit did was look behind, and the dissenters in that, there were 3 judges that said, no, the majority just flat got it wrong. And it said that the majority is establishing, quote, a new rule of law that uses campaign statements to recast the plain, unambiguous, and religiously neutral text of the executive order. That's a quote. They said it can't be done. The Supreme Court said you can't do it, yet they did it anyway. Now, there are 2 other cases that follow Mandel. One is called Fialo in 1977, and basically, once again, it said, and the case here was a man who was trying to bring in his spouse, his wife, and the court and the State Department said no, and Fialo said that's a political question. That's not a judicial question, and affirmed Mandel by saying we can't look behind the facially legitimate and bona fide text of the order. Then in 2015, we have the case of Din, and it looks the same way. A spouse, you have a husband was denied a visa to enter when the wife was here, and this case, and it's only 2 years ago, the Supreme Court said no, in issues of national security, you cannot look behind the text of the order. So what we have is a Supreme Court line of cases that says, no, you can't look behind. You can't go there. But the majority on the Fourth Circuit says, oh no, we're going to go behind, and we're going to say it's not bona fide because of things he said on the campaign trail. Well, Bill Hodes thinks actually the Supreme Court may find the Fourth Circuit was right. A lot of other authorities believe that the Supreme Court will slap them down hard and say, no, Mandel says you can't do that. Obviously, there are real questions, and President Trump is probably wise to let it walk through the courts. But my opinion is that the Supreme Court will say, no, you can't do it. They have a long line of cases that say you can't look behind the text of the order. And so what we will do is wait and see. Hopefully I've cleared up a lot of the complications there, and, thanks for listening.